Hi, welcome to our channel of IGNOU Audiobooks. Indira Gandhi National Open University, School of Continuing Education, Bachelor's Degree Program, Elective Course, Gender Studies, BGSE-01 Gender Sensitization, Society, Culture and Change, Block 5 Gender Law and Society, Unit 16 Sexual Harassment at the Workplace. 16.1 Introduction. Sexual harassment at the workplace has remained an issue of serious concern for the women's movement in India, as it affects the woman's right to work and function in a safe environment. Sexual harassment at the workplace is an extension of sexual harassment of women in public and private spaces. As in all other forms of harassment of violence against women, sexual harassment at the workplace is less about sex and more about an expression and exercise of male power over women that subjugates women and sustains patriarchy. Sexual harassment does not stem from men's inability to control sexual desires, but it stems from the need of some men to assert their power and control over women, including in educational institutions, workplaces, and public places, and to demonstrate male superiority. It is yet another weapon to put women in their place and to teach them a lesson for asserting their right to life with dignity and equality at the workplace. A Times of India survey conducted in 2012 finds that 7 out of 10 women are sexually harassed at the workplace, and that over 90% of them do not register a police complaint because they do not think it would serve any purpose. The Union Minister for Women and Child Development, SMT, Maneka Gandhi, said that in 2014, 526 cases of sexual harassment at the workplace had been reported. Needless to say, this is only the tip of the iceberg, as a majority of the cases go unreported, for reasons discussed more elaborately below. Sexual harassment at the workplace is discriminatory, oppressive, exploitative, causes physical and mental trauma, and thrives in an atmosphere of fear, threat, and reprisal. While men too can sometimes become victims of sexual harassment, in a highly patriarchal society such as in India, it is the women who bear the brunt of this form of harassment. Hence, this unit focuses on sexual harassment of women at the workplace. Let us have a look at the objective of reading this unit. 16.2 Objectives. After reading this unit, you will be able to times explain the concept and meaning of sexual harassment at the workplace. Times illustrate forms of sexual harassment at the workplace and the extent of their prevalence in India and elsewhere, and times highlight various ways of addressing and responding to the same, including through law and social action. 16.3 Sexual harassment at the workplace. Definitions. Sexual harassment at the workplace includes such unwelcome sexually determined behavior, whether directly or by implication, as times physical contact and advances, times a demand or request for sexual favors, times sexually colored remarks, times showing pornography, times any other unwelcome physical, verbal or non-verbal conduct of sexual nature. There are two key issues in understanding the concept of sexual harassment at the workplace. 1. Unwelcome lays focus on the woman's perspective. The focus is on how it affects a woman rather than what was the intention of the act. 2. The conduct should be of a sexual nature. For instance, if an employer or superior discriminates against an employee on the basis of gender and denies her a promotion, but there is no conduct of sexual nature, it will not amount to sexual harassment. Thus, only conduct of a sexual nature comes within the ambit of direct sexual harassment. The illustrations below explain what is meant by conduct of a sexual nature. Box No. 1. Illustrations of sexual harassment at the workplace. Verbal sexual harassment asking for demanding sexual favors, making sexual or obscene comments, jokes, proposals, singing obscene songs, discussing, commenting on women's personal issues such as appearance, marriage, pregnancy, etc., saying something sexually demeaning or humiliating, unwanted phone calls. Nonverbal sexual harassment, staring, leering, whistling, winking, showing pornography or sexually explicit material, indecently exposing body part, smacking lips, blowing kisses, elevator eyes, sending unwanted SMS, MMS, emails, letters with sexual propositions, materials, conduct that makes a woman feel uncomfortable. Physical sexual harassment, physical contact, or advances, unwanted touching, grabbing, holding, pinching, rubbing, blocking a woman's path or cornering her, sexual assault, attempts to molest. The following section discusses forms of sexual harassment at the workplace. 16.4 Forms of sexual harassment at the workplace. Times quid pro quo, sexual favors as a precondition to employment, increment, promotion. This means that a woman would get benefits of being employed or promoted or get an increment or a raise in grade or academic acknowledgement or recommendation only if she consents to the harassment. In other words, the consent to the sexual acts is not freely given by the woman. She consented under pressure that she could lose the rightful benefits if she did not concede to the same. Times retaliatory, refusal to provide sexual favors results in a backlash against the employee. This could be in the form of giving low marks, failing the student in an academic institution, or denying increment, promotion, professional opportunities to the woman in a working environment. Times hostile working environment. Workplace environment becomes sexualized to an extent that the employee's ability to work is affected. This is where the perpetrator may not directly harass the woman, but he may put up a gender-insensitive poster, insist on gender-insensitive computer screens, display pornography, say lewd jokes loudly, and so on, which make it extremely uncomfortable for women to work in that environment. Examples of sexual harassment at the workplace. 1. At an interview for determining increment and promotion, B. The immediate supervisor of A started posing questions to A about her sexual history and preferences of sexual acts. It was implicit that if A did not answer these questions, B would not recommend her for increment or promotion. She found the line of questioning undesirable. B has committed quid pro quo sexual harassment. 2. B. An employer makes a female employee, stay late in the evening at the office on the pretext of work, long after all other workers leave the office for the day. He would then find excuses to sit near her and suggest that they could go together to watch a film. A felt uncomfortable and found the sexual advances unwelcome. So she refused to go out with B. B threatened to dismiss her from the job if she does not go out to the movie with him. B has committed retaliatory sexual harassment. 3. B. The principal of a college calls a girl student to his cabin repeatedly and on flimsy pretexts to discuss studies. In his cabin, he puts up pornographic pictures of women, which make it uncomfortable for A to even step into the cabin. B has sexually harassed A by creating a hostile working environment for her. Attempt the following exercise before reading further. Check your progress. 1. What is understood by sexual harassment at workplace? 2. What are the different forms of sexual harassment at workplace? In the following section you shall read about why women have to pursue sexual harassment at the workplace. 16. 5 causes and features sexual harassment at the workplace. Sexual harassment at the workplace has been a prevailing practice for decades, if not centuries. It became much more prevalent and visible when women stepped out of their homes and took up jobs in big numbers. This threatened the male domination and monopoly in the public sphere. Added to this, women have been increasingly viewed as sexual objects and as targets of sexual attacks in the private and public spheres. Sexual harassment is an act that strikes at the root of women's right to life with dignity and to travel, function, live, study, and work in a safe environment that is free of sexual harassment. Though sexual harassment of women and girls is rampant in many places such as public roads and spaces, public transport, in workspaces in public and private offices, and in educational institutions, it is largely normalized with statements that men will be men and women should be careful. Terms used in everyday discourse, such as ever-teasing and chirchat, aim at trivializing the harm caused to women through such acts, and wrongly implies that the act of sexual harassment is fun and harmless from a societal point of view. Most women suffer from sexual harassment in silence, as there are adverse consequences faced by women who openly speak up against the perpetrator, who is often a male colleague or superior. Employers have often failed in taking action against the perpetrators because they have not considered sexual harassment to be an issue that is serious enough to warrant intervention. It is a worse state of affairs when employers side with and shield the perpetrators and either transfer the complaining woman to another office or discontinue her services as though she was at fault. Here are a few reasons that contribute to the silent tolerance of sexual harassment by the concerned woman. Times the power dynamics at the workplace, man-woman, employer-employee, superior-subordinate. Times a lack of confidence in the organization that action will be taken upon a complaint. Times the stigma and strong social taboo associated with sexual harassment. Times the societal tendency of victim blaming, such as saying that the harassment must have taken place because the woman was not wearing appropriate clothes, because she was at the wrong place at the wrong time, or was giving the wrong signals through her body language. Times peer pressure at the workplace that the women may not get their promotions and increments if they speak up against the perpetrators, and times the woman's possible financial dependence on the job. 16.6 Sexual harassment, myths and reality. There are many myths and commonly held perceptions about sexual harassment of women in the workplace. Such myths are far from reality and serve to undermine justice for the aggrieved woman. Myth 1. Women enjoy sexual harassment, eve teasing. Reality. Sexual harassment is humiliating, intimidating, painful and frightening. Myth 2. It is harmless flirtation. Women who object have no sense of humor. Reality. Behavior that is unwelcome to women cannot be considered harmless or funny. Sexual harassment at the workplace is defined by its impact on the woman, not by intent of the perpetrator. Myth 3. Women keep quiet about it. That means they like it. Reality. Women keep quiet to avoid the stigma attached and retaliation from the harasser, and afraid of being called liars and blamed for the harassment. Myth 4. When women say no, they actually mean yes. Reality. It's a common myth held by men to justify one-sided advances and sexual aggression. When women mean no, they mean no. Myth 5. Sexual harassment is natural male behavior. Boys will be boys. A man is the hunter and the woman is a prey. Reality. Men are not born knowing how to sexually harass others. It's learnt within the context of a sexist and patriarchal environment that perpetuates control over women's sexuality. Myth 6. Women ask for sexual harassment by being provocatively dressed. Decent women do not get harassed. Reality. This is a classic way of shifting the blame from the harasser to the victim. Not all women who are harassed are provocatively dressed. Women have a right to dress, act, and move freely without feeling the threat of harassment. Myth 7. If the woman ignores sexual harassment, it will stop reality. In most cases, the sexual harassment increases as the harasser interprets the silence as silent enjoyment. Myth 8. Women always lie about being sexually harassed. Reality, there is much at stake for the woman once she complains about sexual harassment. There is a stigma attached. She is often blamed for it. She faces hostility and harassment at the workplace, sometimes dismissed, so the possibility is minimal. Activity, case studies. Write a summary report of 2 cases reported in the media covering sexual harassment at workplace. Give the source of information also. 16. 7 responses of the law. Bhamvari Devi's case. Bhamvari Devi was a Dalit woman who worked as a Sathin, a grassroots social worker employed by the Women's Development Project run by the government of Rajasthan. In discharge of her responsibilities at work, she would go from village to village and prevent child marriages. In 1992, when she stopped a child marriage in the village of Bhateri, the upper caste men, who were in favor of child marriages, decided to teach her a lesson and gang raped her. While her gang rape led to a criminal trial that resulted in acquittal of accused persons, Bhamvari Devi's rape also became a flashpoint for the women's movement to demand protection from the employers for discharging their responsibilities at work. A non-governmental organization by the name of Vishaka filed a public interest litigation in the Supreme Court, seeking guidelines in this regard. Guidelines issued by the Supreme Court judgment in Vishaka vs. State of Rajasthan 5. In 1997, the Supreme Court of India passed a landmark judgment observing that sexual harassment at the workplace is a violation of a woman's fundamental right to pursue a trade, occupation or profession of her choice, as guaranteed by the Indian Constitution. This is because she is deprived of a safe working environment. The Supreme Court also emphasized that right to life means right to life with dignity. The primary responsibility for ensuring such safety and dignity was through a suitable legislation by the legislature and the creation of a mechanism for its enforcement. However, as a stopgap arrangement, till such a law was passed by the legislature, the Supreme Court laid down some guidelines that should be followed with regard to sexual harassment at the workplace in order to protect women's rights. The guidelines laid down employers' responsibility for taking due steps to prevent, prohibit, and redress grievances of sexual harassment by establishing a Sexual Harassment Complaints Committee. S. 354 of the Indian Penal Code. Sexual harassment was criminalized in 2013 and spelt out as a punishable offense in S. 354 of the Indian Penal Code, IPC. It includes sexual offenses in public spaces, such as roads, trains, buses, as well as private spaces, such as educational institutions and workplaces. The Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal, Act 2013. 16 years after the Vishaka judgment was pronounced. The Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal, Act 2013 was passed. It has been enacted with the stated objective of providing protection against sexual harassment of women at workplace and prevention and redressal of complaints of sexual harassment and related matters. This is a civil law that lays down measures to prevent and prohibit sexual harassment at the workplace and to provide redress of complainants. It provides for the establishment of complaints committees to investigate and redress grievances. The IPC provision on sexual harassment, discussed above, complements the civil legislation and provides an option to women and girls to pursue remedies under criminal or civil law or both. Both the IPC provision as well as the 2013 Act consider woman to be the victim and man to the perpetrator. After the enactment of the 2013 law, the Vishaka guidelines are no longer operational. S. 354 of the Indian Penal Code. Sexual harassment was criminalized in 2013 and spelt out as a punishable offense in S. 354 of the Indian Penal Code, IPC. It includes sexual offenses in public spaces, such as roads, trains, buses, as well as private spaces, such as educational institutions and workplaces. The Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal, Act 2013. 16 years after the Vishaka judgment was pronounced. The Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal, Act 2013 was passed. It has been enacted with the stated objective of providing protection against sexual harassment of women at workplace and prevention and redressal of complaints of sexual harassment and related matters. This is a civil law that lays down measures to prevent and prohibit sexual harassment at the workplace and to provide redress of complainants. It provides for the establishment of complaints committees to investigate and redress grievances. The IPC provision on sexual harassment, discussed above, complements the civil legislation and provides an option to women and girls to pursue remedies under criminal or civil law or both. Both the IPC provision as well as the 2013 Act consider woman to be the victim and man to the perpetrator. After the enactment of the 2013 law, the Vishaka guidelines are no longer operational. S. 354 of the Indian Penal Code. Sexual harassment was criminalized in 2013 and spelt out as a punishable offense in S. 354 of the Indian Penal Code, IPC. It includes sexual offenses in public spaces, such as roads, trains, buses, as well as private spaces, such as educational institutions and workplaces. The Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal, Act 2013. 16 years after the Vishaka judgment was pronounced. The Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal, Act 2013 was passed. It has been enacted with the stated objective of providing protection against sexual harassment of women at workplace and prevention and redressal of complaints of sexual harassment and related matters. This is a civil law that lays down measures to prevent and prohibit sexual harassment at the workplace and to provide redress of complainants. It provides for the establishment of complaints committees to investigate and redress grievances. The IPC provision on sexual harassment, discussed above, complements the civil legislation and provides an option to women and girls to pursue remedies under criminal or civil law or both. Both the IPC provision as well as the 2013 Act consider woman to be the victim and man to the perpetrator. After the enactment of the 2013 law, the Vishaka guidelines are no longer operational. 16.8 Summing UP. Sexual harassment does not stem from men's inability to control sexual desires. It stems from the need of some men to assert their power and control over women, including in educational institutions, workplaces and public places, and to demonstrate male superiority. Sexual harassment could be non-verbal, verbal or physical in nature. It could be in the form of quid pro quo, retaliation, or creating a hostile working environment. Most women who face sexual harassment at the workplace are intimidated into silence due to the power dynamics at the workplace, a lack of confidence in the organization that action will be taken upon a complaint, the stigma and strong social taboo associated with sexual harassment. The societal tendency of victim blaming and the woman's financial dependence on the job. There are many myths and commonly held perceptions about sexual harassment of women in the workplace. Such myths are far from reality and serve to undermine justice for the aggrieved woman. In 2013, the Parliament inserted S. 354 in the Indian Penal Code, IPC, recognizing sexual harassment as a criminal offense. It also enacted a civil legislation, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act, 2013. Both the IPC provision as well as the 2013 Act consider woman to be the victim and man to the perpetrator. 16.9 Keywords. Case studies. It is a research method in which researcher documents a process of development of a particular situation, a person or a group over a period of time. 16.10 Unit N questions. 1. Explain implications of sexual harassment at workplace on women employees. 2. Explain different forms of sexual harassment. Thank you. We will see you